Now at the patent office, they say they've invented something. They spent nights and weekends and lots of money researching and developing these genetically modified seeds. They're really different and just great whiz-bang things that merit a patent. At the Food and Drug Administration or the U.S. Agriculture Administration or whatever, they say, it's the same food, don't regulate us. We're no different. We don't need to be labeled. We don't need to be regulated. We don't need safety testing because we're exactly the same. But at the patent office, they say we're totally different and we deserve a patent. Okay, so these companies get these patents and then what do they do with them? How many here have ever seen a bag of Monsanto corn seed or canola or soy, cotton? Well, if you look on the back of that bag, there's a little box there that says warning, there's dangers, don't eat this, Larger than that, higher up on the bag, is a box that says, warning, stop. These seeds are protected by our patents. You may only use these seeds in the ways that we allow you to. You cannot redistribute them to anyone else. You can't save seed for a second year. You have to abide by our terms. I actually found this shocking, even as a patent attorney. I found it shocking that more important than the health warnings on these bags is the patent license information. So next time you see one of these bags, if you've never noticed that, take a look. You'll see it. But not only do they patent their seed, put these patents on their bags, make you sign a license agreement, they also will sue people for patent infringement. They've actually sued farmers for infringing their patents on their genetically modified seed. How many people knew that? Yeah. Right, okay. Anybody want to guess how many farmers they've actually sued for patent infringement? Any brave souls want to take a guess? 5, 10? Well, it's actually only 144. But still, 144 lawsuits against farmers, that's a lot of lawsuits. And that doesn't tell us how many threats of lawsuits they've made that have been kept private because the farmer was so scared that they settled and did whatever Monsanto demanded before it got to the point of a lawsuit.
What kind of infringements are the farmers?
Under basic patent law, anyone who makes, uses, sells, or offers to sell a patented thing is committing infringement. And unlike in copyright law, where we have a fair use defense for criticism or for safety checking or other bases that we think is more important than copyright law, in patent law we have no fair use. So even if you just wanted to do research on Monsanto's genetically modified seed, that would be patent infringement. You could be sued and stopped. So if there's a lack of research about their seed, Monsanto is to blame because they prohibit unfettered research on their seed due to their patents. We have no research exception. We have no safety exception to patent infringement. So many of the farmers they've sued are farmers who actually wanted to use Monsanto's genetically modified seed and just didn't abide by the license agreement. They were told you can't save seed for the next season. They saved seed, what have you. But Monsanto has actually also asserted their seed against farmers who didn't want to have anything to do with it. Now, how is that possible? So let me just ask a question. You're growing your crops as you see fit. You don't want to use genetically modified seed. Your neighbor decides to use genetically modified seed. That seed contaminates your property. How many people think you should be able to actually sue your neighbor for that injury? Okay. How many people think the owner of patents on that seed should be able to sue you when you've been contaminated? Okay, well, you can be. Even if you don't know that you've been contaminated. Once your property comes into possession of Monsanto's seed, they can assert their patents against you, and they have done so against others. Okay, if you don't believe me, you can go to my organization's website, which is pubpat.org, or just do a Google search for organic seed versus Monsanto, and you'll find our webpage, which has the CBS Evening News stories profiling people who were accused of patent infringement by Monsanto who never wanted to have anything to do with their seed. Okay, so let's pause that conversation for a minute and let me just step back. A few decades ago, Congress passed a law which many of you might call the Lawyer Full Employment Act. But it was actually called the Declaratory Judgment Act. Let me say that again. Declaratory Judgment Act. And what the Declaratory Judgment Act allows you to do is if you believe you might get sued, you have the right to go to court first, preemptively sue that other person, not to get money, not to stop them from doing anything, but simply to get a ruling from the judge that you're not doing anything wrong. Okay, so why did Congress create this law? Let's say there's one company that's building automobiles, and they have a patent on automobiles, and you want to build a competing company. They send you a letter that says, well, if you build that factory, we'll sue you. Well, Congress wants to allow that person, before they make the investment in building the factory, to preemptively sue the patent holder and get a declaration that says, you could never sue me, therefore I have safety in investing in building this factory. So that's the reasoning behind the Declaratory Judgment Act. So this past spring, we filed on behalf of 83 agricultural organizations, farmers, and seed distributors, a Declaratory Judgment Act lawsuit against Monsanto. We're asking the court to do in our lawsuit. We're not asking the court to award our plaintiffs any money. We're not asking them to necessarily stop Monsanto from distributing their seed. We're merely asking the judge to say that if our clients are ever contaminated by genetically modified seed, Monsanto never has the right to sue them for patent infringement. Okay? That's all we're asking the judge to do. So after we filed the lawsuit, but before we actually served the complaint on Monsanto, because the ball's not actually in their court until you actually serve the complaint on them. You've probably all seen that in the movies, where the guy's trying to find the person to serve them. Okay, so we filed the complaint just to hold our place in line, but we didn't serve it on them. We wrote them a letter, just a simple letter. Hey, you know who we are now. We've gone completely public. We are people who don't want to use your seed. We don't have anything to do with your seed at all. On your website, you say you would never sue people who come to possess trace amounts through inadvertent means. But we're not sure if that protects us or not. So if you would just simply write us back a short little letter saying you would never sue us for patent infringement, we'll go away. Okay? How many people think Monsanto did that? They now have 6 high-priced Washington, D.C. lawyers defending themselves in this lawsuit where all we're asking for is not a single red penny. We're just asking for some peace of mind. Because if our clients are contaminated, it's them that actually suffer the economic injury that threatens their organic certification, their ability to sell into certain markets, their reputation. They're the ones that suffer. Monsanto doesn't suffer when their seed contaminates our client's property. But let me just step back and tell you what some of the arguments are that we're making in the case. Because we can't just go to a judge and say, you should rule that they can never sue us. We actually have to give you a reason why they don't have a basis to sue us. Well, one of them is, of course, just the pure fairness that why should they be able to sue us when it's their product that contaminates us and we didn't want to have anything to do with it. Okay, that's what we call an equitable argument. One of the other arguments we make, most preeminently, that you might find most interesting, is based on the rule of patent law that you can only have a patent on something if it is socially useful. Okay? And there's a very old case, about 150, 160 years old now, by a very well-respected judge, who said, for example, an invention to poison the people is not patentable. So we argue, in our case, if the judge allows us to do so, that patents on genetically modified seed are invalid under patent law itself because genetically modified seed lacks any social utility. And in our initial filing with the court, which you can get from our website, we go into detail with all the scientific evidence that is available, proving that the promises of genetically modified seed have been false. It does not increase yield, does not reduce herbicide use. In the long term, it's actually injurious to not only production capacity, but also the rhizosphere, which is a term I've only recently learned. So in the original complaint that we filed with the court, we document why genetically modified seed does not have the benefits that were promised. And in addition, the evidence shows that it has harmful effects on society. It has harmful environmental effects by increasing the use of glyphosate, which has a residual negative effect on the soil system and the runoff into our water. That there's economic damage by allowing patents on genetically modified seed, because then one seed company can monopolize and streamline seeds, and that there's a threat to society if we allow just a few varieties to exist. We need diversity. And that there's also real reason to believe that there are substantial health effects. Now, my whole time, I didn't really start working on this case till about a year ago when I met a farmer in Virginia who came up to me to talk to me about this after a talk I was giving about another case. And the analogies to tobacco, smoking, or asbestos are just strikingly clear to me. Right? We have a large company or companies that are making a lot of money off a certain product that they swear is safe. They promise it's safe. They keep saying there's no evidence that it's unsafe. But common sense just tells us this hasn't been thoroughly verified. And not just common sense, a lot of the rest of the world doesn't believe this stuff is safe. That's why they reject it. Or they're at least having pause. Let's allow the studies to be done. Let's allow unfettered research to be performed. So that's our lawsuit. And that's why I'm here today. To meet with people who actually do this and have been doing this for a living. I've had my eyes completely wide open throughout this entire experience. I've traveled all around from Maine to California. I was just in San Antonio yesterday speaking with people. This is an important issue. And raising awareness about the case will be helpful to us achieving our ultimate goal, which is to affect consumer opinion and consumer choices. Like, getting a Pyrrhic victory in the courts is not something that's going to actually help my clients. Right? We actually want to educate people and actually change behavior. And we know that Monsanto has access to public relations and press relations at the top of the ladder. So we're going to be more, not to be a pun, but organic about it. And start at the bottom, talking with people, answering questions, meeting people, so that you can then talk to others about it. You can get information about our case.